Hello, this is Matt on the Moon Lambo channel. My friends, this is further vindication for all XRP holders. We were right when we pushed back against the SEC and their BS claims about XRP itself being a security. We were right. The SEC was wrong. Judge Torres ruled, so it is what it is. That's already settled. But you know what's cool here? A judge in a different district in an entirely unrelated court case cited the Judge Torres decision in the SEC v. Ripple case and found that Judge Torres was correct and persuasive. The degree to which that ruling has is now and will continue to impact the entire crypto space, it's hard to overstate just how consequential that was, and we were all a part of that going through that. And yeah, it was hell at the time, but at least we're on the other side of this thing now, at least as XRP holders. I know Ripple's situation isn't completely wrapped up there in the remedies phase, but we're good to go, and we're in a bull market, so we're going to have a good time, I suspect. But I want to share with you perspective on this. I've got perspective from several attorneys. Attorney John Deaton, Ripple's Chief Legal Officer Stuart Alderati, Attorney James Murphy, known as Meta Lawman on X, and Attorney Bill Morgan here. And I just got to tell you, like, this is a stunning rebuke from all the BS nonsense that the SEC has been spouting here. You're going to love this one. I mean, this judge, she is tearing down the BS arguments that the SEC has made on specifically the topic of whether or not an asset itself is a security. And it's the same stuff that we in the community have been saying literally for years. That's why I said at the outset, it's such a vindication for us. We were correct. And now, again, a judge in a completely different district saying, yeah, Judge Torres, absolutely correct. But before going further, I do want to be clear. I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say are right. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so here's the headline from Cointelegraph. Court allows most SEC claims to proceed in Binance suit. So that on the surface doesn't sound too terribly exciting, and it's not XRP specific, the headline, but the story is. I mean, so check this out. Let me just get the lay of the land here for you, and then once we get through this little beginning part of the video, the rest of it's entirely about what it means, what this means for cryptocurrencies in general because of XRP and what happened in the SEC v. Ripple case. Cryptocurrency exchange Binance has failed to convince a United States court to dismiss most claims made against it by the country's securities regulator. Claims related to Binance's staking program, the sale of BNB after its initial coin offering, and anti-fraud violations will proceed, Judge Amy Berman Jackson stated in a June 28th court filing. The security regulators claim that former Binance CEO CZ acted as a control person will also proceed, as will its claim that Binance was obligated to register under the Exchange Act. But it wasn't a clean sweep for Securities and Exchange Commission, with Jackson ultimately deciding to dismiss claims related to BNB secondary market sales and all sales related to Binance USD stablecoin. Okay, so that is where it gets interesting. I wanted to give you a lay of the land so you could know what happened specifically in the case. It's certainly relevant, but the rest of it all has to do with what happened with, well, two XRP holders certainly, but in the SEC v. Ripple case. So Fox Business journalist Eleanor Terrett, she shared this post, and since I am going to be sharing perspective from multiple attorneys, there's a little bit of overlap, but I'm going to try and keep that to a minimum. And the way that I structured the video, there shouldn't be a ton, because I know it gets boring if you just keep hearing the same people saying the same things over and over again, but it's not much anyway. But here's what Eleanor Terrett said. New, a big win for clarity over secondary market sales of digital assets. District Judge Amy Berman Jackson has just dismissed the SEC's claim that secondary sales of Binance's BNB token qualify as securities under the Howey test, citing Ripple's Judge Annalisa Torres' opinion that the economic reality of the token's transactions mattered when applying to Howey. In her opinion, she states, so this is directly from the judge in an unrelated case, the government's reliance on the assertion that the crypto assets are the embodiment of the investment contract, and its argument at the hearing about the nature of the technology and the interdependence of the platform and the performance of every token is not enough, standing alone, to bring secondary sales of BNB under the investment contract rubric. So let's pause and note, we're talking about transactions occurring on exchanges where you don't even know who the hell you're buying from because it's all masked. And she specifically cited the embodiment theory, which I've been ripping to shreds on this channel. I'm certainly not the only one, but I have been ripping to shreds, even leading up to the conclusion, at least from, in terms of legal clarity for XRP, even leading up to that, for years, shredding this damn thing. So XRP just, it represents the investment contract. So the SEC, as I've said for many times, they're speaking out of both sides of their mouth. If you ask them, are you claiming XRP itself as a security? No, it's not a security. Like, oh, okay, then what's going on here? Well, it's the embodiment. It kind of represents all of that. Well, you freaking asshat pricks, that's the same thing. You're speaking out of both sides of your mouths, you freaking idiot sticks. You little spawns of Satan, winged creatures. And then the judge said, moreover, the agreement is somewhat inconsistent with the singular theory the government has been advancing since this action was filed. We aren't saying that the coins are securities. We are talking about investment contracts. Then there was also this short post from Eleanor Terrett. She said, there is no question that the agency, and this is a quote, by the way, from the Binance judge. Again, this is Judge Jackson. There is no question that the agency's position has evolved in that the agency has not undertaken a comprehensive regulatory approach to the industry, end quote. Well, hallelujah. I mean, we've been getting gaslit by the SEC for years. No, everything's very clear. Kim Jong-un is like, oh, no, well, I mean, I'd say it's pretty clear. No, very clear. It's very clear. The guidance and regulations are very clear. Well, the judicial system disagrees with you, Kim Jong-Ginsler. There isn't comprehensive regulatory status for anything crypto-related. There isn't. Right there, she said it in this case. So you listening, you have not been taking crazy pills. The SEC has been gaslighting you. That's exactly what's been happening here. Attorney John Deaton reposted the first post from Eleanor Terrett and wrote the following. He said, I take huge pride in the fact that me and my 75,000 XRP holders played a significant role in getting Judge Torres to rule as she did. Judge Torres not only cited my amicus brief, she cited other briefs as well, but also cited the thousands of affidavits we submitted by XRP holders when she ruled sales of XRP on exchanges did not violate securities laws. She ruled as we requested. XRP itself is not a security. So I'll pause to state right there, absolutely. All of you out there listening, all of us, we all played our roles. Many of you out there, literally thousands of you, filed affidavits. The judge saw that. 75,000 people, represented by Attorney John Deaton, Judge Torres saw that. And even if you didn't, just a lot of us, even just participating in social media, all the reposting, everything. We were all collectively a big voice. And absolutely, Judge Torres was aware of that. And I believe it had a substantial impact because even if things would have gone well for Ripple without this, just kind of broadly speaking, they wouldn't have gone as well. The fact that we were all here made it very clear that she recognized that it was necessary to cite that XRP itself was not a security. She didn't have to do that, by the way. And I'm not convinced that she would have, if not for the XRP community screaming and hollering for years on end. Respectfully, we did, of course. And she saw that, and she responded accordingly. We, as a community, did that. And now everybody else gets to be the beneficiary, which I'm fine with because I hold a bunch of different cryptocurrencies. So I'm happy to see that. Anyway, Deaton continues. Additionally, in footnote 16, Judge Torres cited the conversation between me and Judge Barbadoro in the library case when I appeared as amicus on behalf of Naomi Brockwell. Judge Barbadoro agreed with me at the hearing that his ruling did not apply to secondary market transactions of LBC. We made a difference in the case and in this industry. We will make an even greater difference in this country when I defeat Senator Elizabeth Warren. So that's true. And as far as the library stuff, and that's one thing where I was disappointed, certainly happy that John did what he did, very happy that in the moment, before Judge Barbadoro in the library case gave his official ruling, he's like, yeah, secondary market transactions are clearly not a part of what's cited here. And then, apparently, he became linguini-spined, lost the backbone, and then when he listened, nothing of the sort. He was afraid, because I can only imagine. I mean, nobody knows for sure. I can't get in the guy's head. But to totally do a 180 just on that specific topic, I'm like, You were just afraid to be among the first of judges to do what was right? Is that it? In case it didn't go well for you and your neck's on the line? Like, it's just cowardly if that's what it was. But that was just, so that part was disappointing. But then you have Judge Jackson here in the Binance case is like, no, the asset itself is not the security, clearly siding. Here's what Stuart Alderati had to say. He, of course, is Ripple's chief legal officer. For all the SEC has done to muddy the waters with its inconsistent legal theories, the courts are seeing right through them. The Binance decision last night is long, but absolutely worth a read. Judge Torres and SEC v. Ripple got it right. XRP, in and of itself, is not a security. Other courts are recognizing her decision for what it is. Consistent with the law of the land. Spot on, Stuart Alderati. And then we have this from attorney James Murphy, aka Meta Lawman on social media platform X. Big decision in SEC v. Binance. Judge Jackson relies heavily on the reasoning of Judge Torres in Ripple, and so he's talking about the Ripple lawsuit, of course, and dismisses the SEC's claims based on secondary market sales. Quote, this is the judge in the Binance case. The complaint does not include sufficient facts to support a plausible inference that any particular secondary sales satisfy the Howey test for an investment contract. End quote. That is fantastic. Don't you love to see this? How could secondary sales satisfy the Howey test when you don't even know who the hell you're buying from? Like it was never a coherent argument. And here the judge is like, no, you little SEC bitch asses, that doesn't work. Attorney Murphy continues. The judge makes clear what she thinks of the SEC's approach. The SEC's theory, quote, leaves the court, the industry, and future buyers and sellers with no clear differentiating principle between tokens in the marketplace that are securities and tokens that aren't, end quote. Oh, but Gary Ginzer, you said everything was so clear. Well, why does yet another judge say, no, it's not very clear, including for buyers and sellers in the marketplace? Duh. This is obvious. This is what happens when common sense gets put up against people with their own vested interests, which are against investors just by nature. Because that's what this is. It's unelected bureaucrats with their own ulterior motives, like doing the exact opposite of protecting investors. But when you're talking about a judicial system, which here in the United States isn't perfect, certainly, but vast majority of the time, justice is done, more or less. And that is true, or else we wouldn't have a country. The fact that is the case, so you put up we who are on the right side of history against that, of course we're winning. Of course we're winning, you idiot sticks. What is wrong with these? Well, I know what's wrong with these people at the SEC. They're sociopaths. They're not stupid. I like to call them stupid sometimes. They're not actually stupid. They're just sociopaths. Narcissists. Disgusting people. Lacking morals. They are harming investors with their approach. And they have to know it. They just don't give a damn. But thankfully, the legal system is putting them in their place. Attorney Murphy continues, but the judge was not done with the SEC lawyers. Oh, and check this out. Check out this quote from the judge in this Binance case, Judge Jackson. At the hearing on the motion, the SEC, I love this so much, the SEC seemed to be speaking out of both sides of its mouth on this issue. At several points, it took pains to disavow any intention to argue that once the assets were sold as securities, they retained that character forever, while at others, it left the distinct impression that it was exactly what it meant. End quote. Yes! Oh my God! If you've been following me throughout this SEC v. Ripple case, you've probably heard me like umpteen million times cite exactly that point. And I even use the same language, speaking out of both sides of their mouth. They'll tell you, no, we're not saying that XRP is a security, but then all the arguments indicate, but yeah, it's a security though. It's like that aliens guy. I'm not saying it was aliens, but it was aliens. You know that guy with the crazy hair? You know what I'm talking about. Ancient aliens guy. It's like that. It's like that. So to see the judge absolutely scold them for that, it's just so tasty, so delicious, and nutritious. You gotta love that. Because that's exactly what they were doing. Oh man, I love seeing this. It's such vindication. Because again, they were gaslighting us. No, we're not doing that. Well, the judge disagrees. You were doing it in the Ripple case, and you're doing it in that case, and it ain't working, son. Here's a post from attorney Bill Morgan. So to sum it up, this is what Judge Amy Berman Jackson in her SEC v. Binance decision thought about aspects of the summary judgment decision of Judge Torres in SEC v. Ripple. Number one, Judge Torres' observations on the nature of the token itself were, quote, clarifying and persuasive, end quote. Well, how about that? Number two, Judge Torres' reasoning in respect of the third prong of Howey, expectation of profits based on the efforts of others, that you could distinguish between institutional and programmatic buyers of tokens was preferred to the different reasoning of Judge Rakoff in the Terraform case that you couldn't. The persuasive value of the SEC v. Ripple decision has never looked better. Spot on, Attorney Morgan. Here's another post from him. Judge Amy Berman Jackson also preferred the approach of Judge Torres in differentiating between institutional investors and programmatic retail buyers than the approach of Judge Rakoff in the Terraform case, who did not follow Judge Torres. This will be upsetting to Charles Gasparino, of course, that he's with Fox Business, who has assumed that Judge Torres got it wrong because his attorney sources said so. I guess the SEC's appeal chances against Ripple on programmatic sales may be diminishing a little. Yeah, so Charles Gasparino, he has stated that this doesn't make sense. His logic is absolutely flawed, and I've, in previous videos, explained why in great detail, so I'm not going to do that here. And he also stated that obviously you can't trust Judge Torres. This is a judge who was appointed, a Democrat judge appointed by Obama, and I just gotta say, like, that's not exactly the best argument. I mean, like, I can disagree with any of you out there. Like, say you listening, I'm not getting into politics, but say that you and I disagree on politics. We can still be friends, right? Can't we? And we can still be part of this XRP community, right? And we can still agree that certain things make sense. Like, you're not automatically wrong about everything that you believe, crypto-related or otherwise, even if we disagree on politics, right? So that's a poor argument to say, oh, well, Obama appointed. Well, doesn't freaking matter. So she's just wrong about everything. Or is she only wrong about things if you think that the decision was wrong because of that reason, because of the political reason? And it doesn't make sense. It's not the best argument. I'm just saying that it's wrong. Judge Torres was right here, certainly as it pertains to XRP's legal status. And you're never going to agree with everyone on everything all the time. And so as far as the institutional sales, I don't agree with Judge Torres on that, but it also doesn't matter to me as an XRP holder. So, okay. Then there's this from Attorney Morgan. In the judgment today in SEC v. Binance, Judge Amy Berman Jackson rejected the SEC embodiment theory that the crypto token is the embodiment of an investment contract rather than possibly, in certain circumstances, being the subject of an investment contract. In reaching this conclusion, she considered the issue of the token itself and referred to the Telegram and Ripple cases, and found the observations of the respective judges to be clarifying and persuasive, uppercase for the benefit of CoinDesk, who have legal comprehension problems. I'll just pause to state, CoinDesk, in recent, look, they've been anti-Ripple and anti-XRP since before I jumped into crypto in late 2017, right? They just are. There's a reason we in the community call them FUD desk, right? And I'm going to talk more about this in an upcoming video, maybe later today, because there's a lot to say about this, because they put out another just completely absurd article and just getting all of the key things wrong having to do with XRP's legal status. It's everything wrong, which is why Attorney Morgan is saying what he's saying, but it'd be too much for this video. So anyway, Attorney Morgan continues. Perhaps CoinDesk can review and try and understand this part of the judge's decision, and he points below to highlight. Here, actually, I'm going to make this full screen while I'm reading. Perhaps CoinDesk can review and try and understand this part of the judge's decision and stop writing false crap about the lack of clarity of the XRP token itself, despite the clarifying and persuasive observations about XRP itself not being a security in the summary judgment decision of Judge Torres last year. And I'll pause to say that's because CoinDesk is saying that it's not clear with the recent legal interaction, which I have talked about in a separate video. It's not clear, XRP's legal status. Well, this judge here in the Binance case says it is, and it says it is by citing the SEC v. Ripple case, which just happened. And then he says, hey, Bitcoin maxis, Judge Torres's comments that XRP itself is not a security is not just obiter now. It is now obiter described as persuasive by another judge in a different district. Folks, you love to see it. We win. That's that. We win. XRP, legal clarity forever, man. This is not going away. This, in conjunction with recent crucial wins against the SEC from the Supreme Court, all this like, we're gold. We got legal clarity. We're in a bull market. We're gonna have a fun time. That's my suspicion, anyway. We'll see what markets bring to us and bestow upon us. But I'm very optimistic for the future. And I hope you enjoyed this video because I loved reading through all of this stuff. I'm just having a fantastic time going through this. It's so satisfying after all these years and everything they put all of us through as XRP holders, as a community, to see, no, we weren't just taking crazy pills. You were gaslighting us. And the courts are screaming at your faces that they see through you, you jackasses. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.